Good morning, my Lord. Perhaps I can just briefly summarise where I got to in the argument yesterday. I can really want where I got to was I really made 5 points, but if I can just summarise them. The first was I took you back to paragraph 98 of the judgment, which refers to a contract for the transfer of Taaleem's interest to Sky Gardens, and I referred you to the draft addendum which the parties intended to execute. And you'll recall, my Lord, that that related solely, that single document, to the transfer of the interest under the tripartite agreement, which I'll come to. The second point I made was that there is a significant difference between a contract for the transfer of an interest, be it a beneficial interest under a trust, as it was in this case, or transfer of interest in land, and an actual transfer. The legal test is different, and I took you, by reference to Mr. Kennell's submissions, to the test for the novation, which you, my Lord, had adopted in Tyche number 2, and that the Court of Appeal had approved. And I took you in particular to Proposition 4, you'll remember, that there must be clear evidence, an intention to produce a novation, that the intention of the parties must be consistent only with an actual novation of the contract. The third point I made, my Lord, was that a contract to transfer the interest under the TPA, the tripartite agreement, did not necessarily carry with it a contract to assume the liabilities under the Mirabahar agreement, or an actual transfer of those liabilities. I pointed out that we were talking about 2 quite separate contracts between different parties, and that the finding in paragraph 98 of the judgment does not necessarily include that conclusion. And fourthly, in that context, and I briefly took you to this at the end, we are asking you to confirm the finding in paragraph 98 is limited to the contract to transfer the interest in Sky Gardens. And if one goes to our order in paragraph, if I could ask you to get bundle 4, paragraph, page 369. See that the declaration that we ask you to make is that on the 4th of December 2008 there was a concluded agreement between the claimant and the second defendant for the claimant to transfer its interest in the unit in the property known as Sky Gardens, which is listed at Annex A to this order to the second defendant. And that mirrors, my Lord, paragraph 98. And it is indeed, my Lord, my learned friends who are asking you to go further than that, because they are asking you to make a declaration rather, that that interest was transferred, and that the obligations of Taaleem to repay NBC were also transferred. And one can see that if one goes to the declaration that they are asking you to make at page 328. And if you go to paragraph 1A, you'll see that you've been taken to it already. There's a difference between what your Lordship has found in paragraph 98, we say, and what they're asking you to do in relation to the interest. And in paragraph B, they're asking you to make an additional declaration which isn't mirrored in paragraph 98. And the reason why it matters, my Lord, is this, which is we are asking you to make a declaration in the terms of your judgment, but asking you to clarify that that is limited in important respects context of the 3 points I've made earlier. There is a difference between an actual transfer and a contract for a transfer. There were 2 contracts, 2 different contracts. They're asking you to find an actual transfer in relation to both. And thirdly, when one looks at the actual agreement that was, if you like, in draft on the 4th of December, it was simply the agreement between Taaleem and Deyaar. And the reason I put it like this, my Lord, is because it's not an abuse in our submission for us to take points, the points that we raised in our skeleton argument, in order to ask you simply to make the declaration that you've made. As you will have heard, my learned friend's submissions were all directed to saying, well, you must have implicitly decided more. And in our submission, it must be open to us to point out to you, particularly the pleaded cases that were before the court on the at the trial, and the document. Beg your pardon, and draw your attention to the way, in fact, the way in which the case was being advanced at that particular time. And I think it is striking when one comes to look at the actual pleadings themselves, what both Taaleem and NBC were actually saying about novation and transfer of the interest. If I may go first, please, my Lord, to the tripartite agreement, which you'll find in Bundle 2. Behind tab C, and the page reference we're looking for is C467. It's about 6 or 7 pages in, 2 or 3 pages in.
Was it 67?
67, my Lord.
Yeah.
Be familiar with the document from the trial, my Lord, but the 3 parties are Amlac Finance, DIFCI, and Taaleem. The recitals record the original purchase. Then they agree the equity ratio in recital C, and then they record in recital D that the beneficial ownership of the property shall be vested in Amlac, DIFCI and Taaleem in proportion to their equity ratio. Then paragraph 1 is the parties shall contribute to the purchase price of the property, and there are provisions for reimbursement. C, clause 2 is the parties shall be entitled to receive all proceeds of sale. Clause 3, parties agreed shall be liable for all debts and other liabilities. And then these, the important provisions, my Lord, no party shall sell, transfer, pledge, charge, mortgage, encumber, give or sell at any option or otherwise deal with or dispose of its interest in the property or any of the rights, benefits or obligations attaching thereto, except with the prior written consent of all of the other parties. And then paragraph 5 contains a right of preemption. If any party wishes to sell its interest in the property, it must give the other parties written notice of its intention to sell its interest, and the other parties shall have the first option of purchasing that interest between them in the ratio of their equity ratios to the current market value, such value to be agreed or in default of agreement fixed by an independent value. One of the remaining parties does not wish to purchase the interest being sold, and the other remaining party shall have the option to repurchase the whole of the selling party's interest. And then there are provisions, the mechanism for giving effect to the right of preemption. And then if I could go over the page, my Lord, to page 71. Clause 13, any modification or amendment to any provision of this agreement must be in writing and bear the signature of all parties or their duly authorised representatives. And then there is an arbitration clause in clause 40. So the critical provisions, my Lord, are a prohibition under paragraph 4 against disposing of it or giving or selling any option or otherwise dealing with or disposing of interest, except with the prior written consent of all the parties. And then if any party wishing to sell its interest has got to offer it to sale, so there's a right of preemption. Now, the way the case was advanced by my learned friends in their pleadings, you'll find in Bundle 1. One goes to page A127, it's the first document, it's the particulars of, it's the claim form and particulars of claim, 3 pages in.
So what page?
A127, by the way.
7, yeah.
7.
Yeah. This is the points of claim.
This is the original particulars of claim.
Yeah.
You go to paragraph 25.
Yeah.
The original plea is thus by an agreed process of novation arranged by NBC, Deyaar acquired the interest in the property and became liable to NBC for 2 payments, etc. Entries recording this fact. So the critical thing is that the paragraph 25 originally pleaded an agreed process of novation acquired the interest. And then they were asked for further information of that by NBC. And if one goes forward to A1313, you'll see request 3. Please particularise how the allegedly agreed process of novation has operated. Particularly, please confirm whether any written agreement was entered into between Deyaar and or Taaleem and or NBC in relation to this alleged novation signed by all or any of these parties. Then it asks for the document. And the answer, 3.1, response, Taaleem's interest in the property and liability to national bonds were transferred to Deyaar by a process of novation, alternatively assignment as a result of. And then there are a series of events pleaded, but the 2 which I want to draw your attention to are 3.2 and 3.3. 3.2 I'll just ask you to note for the moment because I'll come back to it in a moment or two. But over the page 3.3, Amlac Sky Gardens LLC and Amlac Finance PJSC gave their written consent on or about 14th May 2009 to the disposition by Taaleem to Deyaar of Taaleem's rights and obligations under the tripartite agreement. So the process of novation, the consent that they're talking about under the tripartite agreement does not come until the 14th of May 2009. And if I could just briefly take you to the relevant document, my lord. You'll find that in bundle E1.
I'm sorry.
I beg your pardon, it's not bundle E1, my lord, it's bundle E2. 3.2, I beg your pardon. 3.2. Page is 5E21 5809. It's about, I would say, halfway through the bundle.
E21
5809.
Yeah.
And it is a letter from Amlac to Taaleem and to Deyaar, dated the 14th of May 2009. Amlac Finance and Amlac Sky Gardens, represented herein by Arif Alhami, does hereby waive compliance with the provisions of clause 5 of the tripartite agreement, concluded with Taaleem and DFCI, and hereby specifically records its acknowledgement of and consent to the disposition of Taaleem and its rights and obligations under and in terms of the agreement to Deyaar, and on such conditions as the parties may agree with in respect to the transfer of Taaleem's shares to Deyaar. So my point is this, my lord, which is that the pleaded case was that the novation itself did not in fact take place until 14th of May 2009. You can see that consent was given at that stage. Wasn't given any earlier, wasn't pleaded that there was any earlier consent given, my lord. So at the time of 4th of December 2009, there could only have been a contract to transfer the interest rather than an actual novation at that stage.
I don't remember any such point being made. Can you show me where that point was?
I'm not suggesting that it was made, my lord, but it is I'm suggesting that that's the reason why the findings should be limited in the way that I suggest.
No, but it would be a point that needed to be made, wouldn't it? Because the whole purpose of the exercise of the hearing that took place whenever it was, gosh, a year ago, I suppose, not much sure when, was to try and resolve the issues of liability, and it would be a matter of some significance if the events that culminated in on the eve of the amendment to the tripartite agreement had no contractual impact at all.
I'm not suggesting they had no contractual impact. I'm saying that there was a contract to transfer the interest as your lordship has found. They could have been perfectly possible as between the two parties.
I agree. If you just look at paragraph 98 of the judgment, that would be a point that one could, in a sense, at least make. But we are just, one has to stand back from the judgment a bit and look at the entirety of it, surely. Well, the only point I'm simply seeking to make is that if there was an issue about the existence of or date of consent by the other interested parties, you would have thought that would be a point that would be made to me by the defendants. I don't remember them ever doing so.
Well, I can't say that it was made, my lord, but my point is to you is that what one has to do is to...
What one has to do is to try and see what decision I made about what the issue was before me.
Well, the issue, as my learned friend Mr. Flynn took you to yesterday, my lord, was effectively agreement or no.
Right.
And my point is that that does not determine the ultimate liability.
Well, then it wasn't a very good question. The whole point of the hearing was to determine it. Otherwise, you're just wasting money. It's wholly unreal, this, isn't it? Anyway, there you are. You accept that this is not a point that was ever raised. You say it wasn't raised because it didn't need to be raised because all that had to be decided was whether there was a contract of some kind.
The critical issue and the issue number one, if one goes to the list of issues, my lord, which you'll find in bundle 4.
Yeah. Yeah.
At page 289.
Okay. Sorry. Yeah.
The issue that your lordship was asked to decide and did decide at the trial was issue 1.
Yeah.
Did Deyaar and Taaleem enter into a legally binding agreement under which Deyaar assumed or agreed to acquire Taaleem's rights and obligations in respect of Sky Gardens, including Taaleem's obligation to repay NBC in respect of the financing which it provided Taaleem to purchase the interest in Sky Gardens? Now that question was capable of a number of different answers. It was capable of the answer, yes, there was an agreement to to assume, Deyaar actually assumed the liabilities, assumed the rights and obligations, or it assumed the rights but not the obligations, or it agreed to assume the rights but not the obligations. Those are the three possible outcomes. And those do have a very significant effect on the current rights and obligations of the parties going forward. And when we appealed, we were told by the Court of Appeal that the right course was not to take the issue to them, but to come back to you and ask you to resolve the outcome. What were the terms of this contract? Did NBC assume them? Did Deyaar agree to or assume the liabilities, or did it assume the liabilities? And at that point, one could make further declarations. And all I'm seeking to point out to you is that the finding in 98A, in the context, is a finding that Deyaar agreed to acquire the interest. That was the answer that your lordship gave. Now, my learned friends are saying you must have given a much wider answer to that question. They're saying there was a novation. There was a novation of two different contracts. And my submission is that that's not right, and your lordship hasn't found that that's right. And one can test that this way, which is, my lord, which is novation is a legal term of art. There's a specific article in the contract law, Article 102, which deals specifically with novation. Now, if one goes to the judgment, which is, you'll find at page 98 of the law.
I'm sorry?
Sorry, if one goes to the judgment, which one finds at immediately behind the list of issues at 294. Yeah. 293, I beg your pardon. 292 it starts at. One looks through.
What page do you want me to go to?
Just 292 is the judgment. There is only one reference to novation in the entirety of the judgment,
right,
which is at 294.
Thank you.
Paragraph 9. And that's simply a recital, my lord, of the declaration that Taaleem was seeking. And I put it the other way around, my lord, is that if my learned friends had been seeking to establish that there was a novation, two separate contracts, which had the effects for which they now contend, they should have been asking for those findings. The simple question, agreement or no, does not answer that question. I mean, it was the live issue because our case was that there was no agreement at all. In their case, well, there was an agreement. But the thing that they never asked you to do was to find, and I'm going to come back to this in relation to one particular issue, which is the 81 million liability under the NBC, is they never asked you to find, can you tell us, please, what the precise terms of that agreement were, and that it involved an assumption of the rights and obligations under these two separate contracts. And one can quite see why they didn't choose to put it that way. Because as soon as one does begin to answer those kinds of questions, it poses all sorts of difficulties. One of which is the one I've just identified, which is that, in fact, there could not have been a novation of the tripartite agreement on the 4th of December 2008. I'm sure Mr. Flynn is a very skillful advocate, but one could quite see why he wanted to reduce the question to a very, very simple question, agreement or no. But what he didn't say to you, or ask you to find, was that there was a novation of this agreement whereby the interest had effectively passed. And one can test this very, very simply. I mean, if one stands back and says, could Deyaar have enforced the tripartite agreement on the 5th of December 2008, the answer is obvious. Had no interest. Indeed, Taaleem had no interest to pass on at that date. Because there was a right of preemption. The only way in which it actually had a right to pass on the shares was by the shares in the beneficial interest was by obtaining a waiver of AMLAC Finance and DIFC to the right of preemption, which didn't occur until the 14th of May 2009. So what one is left with it, yes, there's a binding agreement, but it is simply a contract to transfer the interest, and therefore...
Well, I mean, there was no equivalent to written consent from DIFCC, was there?
The DIFCI drops out of the picture in March 2009. It sold its interest to AMLAC Finance under the Memorandum of Understanding. So by the time you get to the 14th of May, there's only one counterparty, effectively, which is AMLAC Finance. I'm going to be taking you to that. So that there is... DIFC effectively drops out of the picture under the Memorandum of Understanding in 29th of March. So, but it hadn't gone by, it was still a counterparty at this stage, 4th of December 2011. So my point is that simply that the finding that your Lordship has made is entirely consistent with what we say happened. What we say is that there is a contract for the transfer of interest because at that stage, Taaleem could not have done anything more. And if my learned friends had been wanting to ask you to make a finding that there was an actual novation, they should have done so, because it is different. And this becomes even more important when one gets to the Murabbaha agreement. So if we put away the judgment for just one moment and go back to bundle 2, C363, please, my Lord. Going to be making a number of points on the Murabbaha agreement, my Lord. Some of those relate specifically to quantification, which in my submission must be open to me to take at this stage, given that this is a quantum here. But there's a wider point as well, my Lord. So I'll just identify the important provisions, if I may, on the way through, and then I'll come back to them. So you can see that the national NBC and Taaleem are the parties. And then Clause 2, in consideration of the sale price defined in Clause 3.1 below, in accordance with the terms and conditions of the promise and this agreement. The promise, my Lord, under the Murabbaha agreement is a separate promise to pay. I won't take you to that, my Lord. But it is in the bundle. The seller hereby sells by way of Murabbaha to the buyer, and the buyer purchases the property as more particularly described in Annexure 1, and then sale price in terms of payment. The sale price of the property by way of Murabbaha under this agreement is, and then there's the 136 million with the following breakdown. There's the cost price and the profit. Just ask you to notice, my Lord, that there's only a single figure for profit there. It's a single profit, and that was paid by Taaleem, 1,492,000. Then if we could go over the payment of sale price. The buyer shall pay the sale price in accordance with Annexure 2 of this agreement on the due date. If, however, it fails to pay on the due date, it shall be obliged to pay such amount on the next instalment date, including the amount to be paid on that instalment. If it fails to pay 2 consecutive instalments on their due dates for any reason, all the remaining instalments shall become due, and upon receiving a written notice from the seller, the buyer shall be liable to pay all the remaining outstanding amounts instalments in one bullet payment, with the period mentioned in the said notice. Come back to the notice in a moment or two, my Lord. 4.2 is an important clause, which I just want to draw to your attention, and again I'll come back to it. In addition to the buyer's liability under clause 4.1, the buyer shall also be liable to compensate the seller for the actual loss caused to the seller due to the buyer's failure to pay, in accordance with clause 3.2 and the payment schedule specified in Annexure 2, unless otherwise determined by the competent court or arbitration, or as reasonably determined by the seller. The parties agree that the amount of the late payment charges shall be 2% of the total amount payable by the buyer hereunder, not being paid on the due date. Seller shall be entitled to receive the late payment charges specified in this clause 4.2 from the buyer, and shall, after deducting its actual loss, donate on behalf of the buyer the same to charities under the supervision of the seller's Sharia board. I read those to you because they're quite important provisions which we'll come back to, my Lord. For present purposes, what I want you to focus on, my Lord, there's clause 13 is the governing law on C364, which I just asked you to note for the moment. And then on paragraph 7, clause 17, amendment, assignment. No amendment to the terms and conditions of this agreement is valid unless, with the written mutual consent of the parties, the buyer shall not be entitled to assign or transfer all or any of its rights, benefits and obligations hereunder. Seller may, subject to the seller's Sharia board's approval, at any time assign all or any of its rights and benefits hereunder, provided that, save in the case of any such assignment to any subsidiary of the seller, no such assignment may be made without prior notification to the buyer. So again, this document contains an absolute prohibition on assignment, and also the clause at 17 in relation to amendment. So if one then goes back to the pleaded case, which one finds in bundle 1, again, take you back then to A1, page 313. National Bonds gave its written consent on or about the 12th of April 2009 to the assignment of Taaleem's obligations under the Murabahar Agreement to Deyaar. And then if one goes forward, please, to page 55, this is NBC's case.
Sorry, page what?
Page 55, this is NBC's defence and counterclaim.
Yeah.
By a letter dated 12th of April 2009, NBC agreed in principle to the transfer of Taaleem's financial obligations to Deyaar. It's clear from both Taaleem's claim and Deyaar's defence and counterclaim that there is now a dispute between Taaleem and Deyaar as to whether there was any effective binding transfer, and two, as to who is responsible to repay NBC the monies admittedly advanced by NBC. And the critical, so Deyaar's position going into the trial was that there was an agreement in principle on the 12th of April 2009. And that agreement in principle, my Lord, can be found at C14.
So where do you want to go?
Bundle 2, I beg your pardon, my Lord. It's in the core bundle, bundle C, and you will find it towards the middle of that. C14.
Yeah.
One 4.2. There's only one document from C14 in the law.
Yeah.
And you'll find the reference, it's a letter which was referred to the audit for the year ended 31st of August. The critical part is at the bottom. National Bonds Corporation hereby confirms the balances are mentioned above due from Taaleem as at 31st is or is not in agreement with our records. Furthermore, we confirm that pursuant to the sales purchase agreement to be entered between Taaleem PJSC and Deyaar PJSC with regard to acquisition by Deyaar of 33% of Taaleem's stake in Sky Gardens Tower, etc. We have no objection in Taaleem's liability under the Murabahar Agreement dated 6th July 2008 being signed on to Deyaar PJSC. So that's the consent that's given and pleaded, and it is a consent for the future. And again, if one goes to the SPA, which is the immediate document following, final draft of the SPA, one finds that even then they've still not agreed the actual terms between Deyaar and Taaleem had agreed in principle what was to happen, but they hadn't actually negotiated final terms with NBC, because if one goes to clause 11, which is on page 251,
Mm-hmm.
parties acknowledge and agree that the buyer will negotiate directly with National Bonds Corporation on the subject of any advances made to or liabilities incurred by the seller in respect of the property or the project interest. Only for the avoidance of doubt, it's acknowledged that the seller remains responsible for any financing cost or liability attributable to the national bonds that arises up until 30th of August, and the buyer shall be responsible for any financing cost or liability attributable from 30th of August 2000 onwards. And then the final sentence. But it's the first sentence I draw to your attention, because even then, even by, I think the document was finalised towards the end of March or during April, much the same time as the letter we've looked at. We've still got no final agreement between Deyaar and NBC. And so what one comes back to, my Lord, is that we submit that it's the point being put to you by my learned friends, it is in fact put the wrong way around. If they'd been asking for a finding, an actual finding, or they should have been asking for an actual finding that there was a novation, because they needed that in relation to the transfer of assets and liabilities. You can see again, as I submit, my Lord, exactly why they posed the question that they did, because once one actually asked the question, direct question, was there a novation of the contract between the tripartite agreement, was there a novation of the Marabahar agreement, one arrives at different conclusions in our submission. In fact, one is driven to the conclusion that there was no agreement between NBC and Deyaar as at 4th of December 2008. So in our submission, the right way to look at this is the question that you were asked, my Lord, was there agreement or no on the 4th of December 2008? The answer is yes, there was an agreement. It's the agreement that your Lordship has identified. That was the question you were asked, and that was the question that you were answered. But it's insufficient for the claimant and NBC in this case to establish, one, that there was an actual transfer, and secondly, of the rights under the tripartite agreement, and secondly, that it's insufficient to enable them to establish a finding that there was a novation of the liabilities to NBC. Indeed, the question, perhaps it's rhetorical or not, but it does strike us, and we accept again that we are new to this case, it's very, very odd how NBC and Taaleem can both be arguing that there was a novation of the Marabahar agreement on the 4th of December 2008, when NBC appeared to have been completely unaware of it. One would have thought that the parties must have known if there was an assumption of liabilities on the 4th of December 2008 by Deyaar, that NBC must have known this. But NBC's case wasn't that there was a contract between it and Deyaar after the 4th of December 2008. Its case, as we've seen, was simply that there was an agreement in principle in April 2008. And that, in our submission, is why it's not an abuse for us to raise these points now. In our submission, a very respectful submission, your Lordship was not asked to answer the questions that were essential in order for the claimants to prove, to establish the declarations in this case that they're asking for, and to establish the liabilities. I now want to move on, my Lord, to look at the liabilities, if I may, under the Marabahar agreement. I make 2 points really in relation to this.
So now this goes to what aspect of the preparation of an order?
This goes to two aspects.
Right.
The first, it goes to the question whether there was any agreement between NBC and Deyaar on the 4th of December 2008. And then secondly, it goes to the actual obligations which Deyaar has assumed, if or can be taken to have assumed. The reason I make those 2 points clearly to you, because your Lordship may be unpersuaded by me that in fact you didn't answer the question whether there was an ovation or a contract to assume the liabilities. But my alternative submission is that it must be open to Deyaar to challenge the quantum of their liabilities in relation to in effect, what was owed by Taaleem to NBC.
Yeah.
And that is an issue which is not without difficulty. And I don't think, or maybe I'll be proved wrong, that my learned friends will assert that you purported to decide how much, even if you decided whether Deyaar has assumed any liabilities. I don't think that.
Just say that again. I didn't understand it.
I'm not sure whether my learned friends are arguing that you've also determined how much we are liable to pay to NBC, even if they are submitting that you've determined whether we are liable to NBC. So there are two questions. Are we liable? Did we assume an obligation?
Well, they are asking for a money judgment.
Well, they are asking for a money judgment. But, and they do appear to be saying that the amount of that should have been determined in the first trial.
Anyway, yes.
They are asking for a money judgment, but I'm going to deal with that. So the first question, the two really run together in some ways, my lord. If we could go back to the Murabahar agreement, if one has if you're still in bundle C2, bundle C, I beg your pardon.
Bundle
C. Does your lordship have bundle C open?
I'm sorry, bundle C.
Bundle 2, I beg your pardon.
Yeah, I have got bundle 2. Yeah.
If you go to the very front of tab C, my lord, back to the Murabahar agreement.
Yeah.
And if we could then go to clause 4.1.
Yes.
The first thing is that there was never any schedule annexed to the Murabahar agreement.
So I don't see the reference to it at the moment.
The buyer shall pay the sale price in accordance with Annexure 2 payment.
Oh, I see, I'm sorry, yeah.
And the explanation given for that, you'll find, my lord, in NBC's submissions in Bundle 4. If I could ask you to keep the Murabahar agreement, the Bundle 2 open where it is for the moment, and go to Bundle 4.
Yeah.
And go to page 99. I beg your pardon. Page 100. And if one goes to 1412, the Roman 2, clause 4.1, says payment by Taaleem was to be made pursuant to a schedule at Annexure 2. However, a payment schedule was not included, which was by oversight, as Mr. Subi explains. And then it says if an instalment was missed, then it would be payable on the next instalment date. If two consecutive instalments were missed, then all remaining instalments would fall due upon written notice for NBC. But it's difficult to see how one can operate the mechanism of clause 4.1 without the payment schedule. And at this stage, it appears clear that what was happening was that NBC was negotiating, on 4th of December at least, NBC was negotiating with Deyaar over whether to fund all of the payments and over what period. The next point I wanted to take your lordship to is still in NBC's submissions. If I could ask you to go on to page 165, paragraph 165.
So now we're in paragraphs. Yeah, all right.
Page 105, my lord, I'm sorry.
Yes.
As Mr. Subi explains, despite having made the fourth payment of AED 81 million in September 2008 referred to above at paragraph 134, Taaleem refused to enter into a Murabaha agreement in relation to payments which post-dated its financial year end on the 31st of August 2008 and said that NBC should look to Deyaar. So at that stage, it is important that one remembers the chronology at this stage, my lord, because what's happened is that the Murabaha agreement, you'll remember, my lord, is backdated. You can see that. Go back to 129, my lord.
Go back
to page 96.
Yeah.
It's paragraph 125.
Yeah.
Murabaha was signed during October 2008. Mr. Kapoor suggests that it was signed on around 21st of October 2008. Mr. Subi agrees that it was around this time. So what you have is the payments made up until the 31st of August. There's then a further payment, because the initial, you'll recall, my lord, that the initial expectation was that Taaleem would have sold its interest by the 31st of August 2008, but it was unable to do so. So on the 12th of September 2008, there is then a further payment of 81 million.
Yeah.
On about the 21st of October 2008, they signed the Murabaha agreement. I'm getting it wrong, my lord. I hope everybody will forgive me. The Murabaha agreement, and the curiosity about the Murabaha agreement is it does not include the 81 million.
Yeah.
That figure was left at large. And the only other point in context I'd make in relation to that, my lord, is you'll remember that NBC and Taaleem are associated companies. And you get that out of, you can get that out of the, perhaps best to go to the witness statement. Probably, if one puts away my learned friend's submissions in bundle 4 for the moment, my lord, and goes back to bundle 1, and I'll be going to the pleadings in a moment or two.
Yeah.
You'll find the witness statement of Mr. Kapoor immediately behind the tab B1 in bundle 1. Just refresh your memory, my lord, of paragraphs 21 of the witness statement, page B1 317. That sets out the merger with Madaris as Taaleem was growing and creating a pipeline of school projects that needed funding. NBC established Madaris in February 2007. The merger proposal was attractive to Taaleem and Beacon. Prior to the mergers, the shareholders of Madaris were aware that Taaleem had losses. At that time, Madaris had around 85 institutional and high net worth individual shareholders, with NBC owning approximately 20% of the shares. By 1st of September 2007, Madaris had acquired 100% of Taaleem and Beacon, with only 2 exceptions. All existing shareholders of Taaleem and Beacon swapped their shares for shares in Madaris. So NBC is the largest single shareholder, ultimate shareholder in Taaleem. It's described by my learned friends in their pleading as an affiliated company, which I'm happy to accept. So what one has here is a formal agreement signed on the 21st of October and then backdated to the 31st of October, and in effect an intercompany advance of 81 million between affiliated companies on the 12th of September, which is not included in the Murabaha agreement. And if one then look at the way it was dealt with, as the issue was pleaded, if one goes back to bundle to tab A1 in bundle 1, go to page A1467.
So shall we just repeat the reference?
A1 oblique 4 oblique 67.
Yeah.
The way it was pleaded is 94. This is NBC's defence and counterclaim. In the event Taaleem did not realise its investment in the property on or before 31st August 2008, in the premises NBC made a further payment of the 81 million in order to enable Taaleem to pay AMLAC in satisfaction of Taaleem's obligations under the tripartite agreement. And that's it. It's the plea in relation to that. And then in page paragraph 103 on page 69, summary of the payments made by NBC and owing and thus far repaid to NBC is set out below and were provided in the NBC statement of account dated 25th May 2010. It's already in evidence in the proceeding. It doesn't appear in the trial bundle, and we've not seen it, that statement of account. But then over the page, you'll see, my lord, and then you can see the figures. Profit, late payment fees. There's a partial repayment which is made by Deyaar on the 9th of April, and then there's the Murabaha agreement profit, which was paid by Taaleem, and the net figure is, or the principal at least, is the sum of AED 166529699 is due and owing to NBC by Taaleem under the Murabaha sale agreement and or due and owing by Deyaar, whether pursuant to DIFC law or UAE law, and NBC hereby demands repayment of the same. And if then one looks at the way that is dealt with in the reply and defence to NBC's counterclaim.
So how does that figure emerge from that schedule?
I think that's the payment, that's the principal sum, my lord, after one strips out the profit. So one ignores
so
the 166
the payment fees and the it doesn't include the 7 million.
That doesn't
look right. It must include the 50 million. Anyway, don't worry, let's not waste too much time.
I can tell you immediately what it is, my lord. It's the 216529699, so that's the payments of principal made.
Right.
Less the 50 million paid by us.
Oh, I see.
Ignoring the profit figures, which we'll come to.
Ignoring profit and ignoring late payment fees.
Yeah.
Okay.
And that's the payment of principal that's actually claimed in these proceedings.
Yeah.
If one goes then on to A17140, my lord.
Yeah.
Or 139 perhaps, my lord, to start with. So 89.2, which is dealing with the I should perhaps, before I just take you to this, might ask you just keep your finger on page 139 and go back to NBC's pleading at page A1466. The allegation in 89.2, which has been answered when we come to look at it, is in relation to Section F of the particulars of claim. NBC avers that Taaleem has been unjustly enriched by both the monies totaling AED 216 million and also by the premium paid by Deyaar to Taaleem, and Taaleem must repay the monies advanced by NBC in their entirety. So there's a claim of unjust enrichment, which proceeds. So if one then goes to paragraph 48 of the reply and defence to counterclaim,
Yes.
Subparagraph 89.2 is denied. It's denied that Taaleem has been unjustly enriched, admitted that NBC advanced a total of 135 to Amlac Finance for the benefit of Taaleem. These monies were subsequently made the subject of the Murabaha agreement. NBC has repaid 50 million, has been repaid 50 million. 12th of September, NBC paid a further sum of 81 million. And then thereafter, as set out herein and or in the particulars of claim and response, Taaleem's obligations to NBC under the Murabaha agreement were transferred to Deyaar. And then there's the remaining pleas. And then it's denied that NBC advanced the premium. Those monies are irrelevant to any claim for unjust enrichment. Same as set out above, subparagraph 89.2 is denied. And then over the page 57, paragraph 99, it's admitted that Taaleem paid to NBC the profit of AED 1492, etc. It's admitted that
where are you reading?
57, paragraph 57 on the following.
Yeah, I've got it now. Yes, I'm sorry. Yeah.
It's admitted that Taaleem has made no further relevant payments to NBC. It's denied that Taaleem is obliged to pay NBC any monies due under the Murabaha agreement. Taaleem's liabilities under the Murabaha agreement were transferred to Deyaar. And then I will read E, if I may, my Lord. Any monies paid to NBC under clause 4.2 of the Murabaha agreement would be held on trust by NBC for charitable purposes, and or NBC would be obliged, pursuant to the terms of clause 4.2, to apply those monies to charitable purposes. So as set out above, paragraph 99 is not admitted. And then as to paragraph 103, page 141, admitted that NBC advanced the total there. Payments alleged in the second row are unparticularised and undenied. The only profit due under the Murabaha agreement was paid by Taaleem to NBC. And again, my Lord, it keeps one's finger in 141. And goes back to the table that we were looking to a moment ago, my Lord. You find at page A1470, it's about an inch back.
Yeah.
It says the payments alleged in the second row are unparticularised and denied. The only profit due under the Murabaha agreement was paid by Taaleem to NBC. It's not admitted that late payment fees are due to NBC under the Murabaha agreement. Any such fees, 1, will be limited to 2% of the contract sum, being AED 2,706,621.23, and would, 2, once received, be held on trust by NBC for application to charitable purposes in accordance with clause 4.2 of the Murabaha agreement, and or NBC would be obliged, pursuant to the terms of that clause, to apply those monies to charitable purposes. Denied that the sums claimed in the third row, and that's the late payment fees, due under the Murabaha agreement. It's admitted that the sum stated in the fourth row was paid to NBC in partial repayment of the sums due under the Murabaha agreement. I'm going to take you back in a moment or two, but the position as we went into the trial is that the sums being claimed by NBC are effectively unparticularised. They don't correspond to the terms of the Murabaha agreement themselves. And the point being taken by, at least by Taaleem at that stage, was that it's only the obligations under the liabilities under the Murabaha agreement that were being transferred to Deyaar. And if one then goes to the submissions that were made at the outset of the trial, put away bundle 1 for the moment, go back to bundle 4, if I could go, please, my Lord, first to page 14, this is my Taaleem submissions.
You say 14?
Page 14, my Lord.
Yeah.
And paragraph 43.
Oh dear, sorry. Bundle 4, page 14.
14, my lord.
Oh, 14, I'm so sorry.
It's my poor diction, I'm afraid.
Yeah.
So paragraph 43, a finance agreement was discussed in August 2008 but was not signed until late October. On that date, Taaleem and National Bonds entered into the Murabaha. The Murabaha covered those payments which had been made to 31st of August in total, 135,331, circa 23.1 million and $36.8 million. Thereafter, the intention was to sign a new financing agreement with the prospective purchaser of the Sky Gardens interest from Taaleem. And then if one goes forward to page 49,
Yeah.
to paragraph 288, bottom of the page 49, if the court finds that there was no binding agreement to transfer, it's accepted that Taaleem would remain liable to national bonds under the Murabaha. It is further accepted that Taaleem will be liable in restitution to national bonds for the further payments made by national bonds. So there are two issues really in relation to the liabilities. One is, was there ever a contractual liability to repay the 81 million which was assigned or transferred to Deyaar? And that's not an issue which the court was asked to decide. It was not asked to decide what the basis, whether there was in fact a liability in relation to a restitutionary liability in relation to that 81 million, or declare the basis on which the 81 million was paid. And secondly, there was an issue between the parties as to the amounts due under the Murabaha agreement. Now, in relation to the first issue, we simply say that there was no agreement between, no pleaded agreement between Taaleem and Deyaar, or accepted by Taaleem and NBC, I beg your pardon, but accepted by NBC. In fact, it's clear that what was intended was that whoever acquired the interest would be asked to enter into a Murabaha agreement, but that never happened. Insofar as there was any liability from Taaleem, that could only have been a liability in restitution. The court wasn't asked to decide that issue. And that cannot be, in our very respectful submission, drawn out of paragraph 98 of the judgment. And thirdly, there is this problem, which is how does one assign or transfer a liability in restitution on the 4th of December? May well have been a claim against Deyaar that it would have been liable in restitution for 81 million. It wouldn't have been an easy claim because it never received the money. Might have well have been questions about what system of law governed that liability. But my learned friend, Mr. Kennon, airily states in his skeleton argument, I think it's paragraph 78, oh, well, there's no problem. You can just assign the restitutionary liability. You can just treat the liability as having been assigned to Deyaar. And that's on page 19 of his skeleton argument. simply says in the first sentence, the very top of the page, but even if Taaleem is only liable in restitution, there's no reason why that liability was not assigned, novated to Deyaar. And we do take issue with that. First of all, there has to be an established liability. And secondly, one asks oneself, well, how can that be novated? Novation is a principle that applies to contracts. There is a specific provision in the contract law dealing with the assignment and novation of obligations, and I'll just take you through it because it's an obvious point, but I think it's worth making. Which is tab 1 of the authorities bundle. Tab 1 of volume 1 of the authorities bundle. One goes to page 21 of the contract law, page 21 of the document.
Well, what's the page in the bundle?
It's 283, I've got my book.
Okay.
I'm not sure why the numbering is. It starts at 257, it's 283.
283?
So,
yeah.
Article 92, assignment of rights and obligations. An assignment of a contractual right is a transfer by virtue of which the assignor's right to performance by the obligor is extinguished in whole or in part, and the assignee acquires a right to such performance. An assignment of a contractual obligation is delegation of the obligation to the assignee. And then an assignment of a contract. And then you have 102, page 285. And novation is a substituted contract that includes as a party one who is neither the obligor nor the obligee of the original obligation, and the substituted contract is 101 above. Substituted contract is a contract that is in itself accepted by the obligee in satisfaction of the obligor's existing obligation, and then it discharges the original obligation. So those are all contractual matters, whereas if one goes to liability and restitution law, which one finds in tab 2, that's 305. This is a remedy. It comes in the law of damages and remedies.
You say 305?
Page 305, and one goes to page 317, page 13 of the document, page 317.
Yeah.
Article 48, under Part 5, remedies in the law of restitution. Restitution is available where the remedy is expressly provided in the DISA contract law, or where there has been an unjust enrichment of one party at the expense of another party. There's been no subsequent change of position, which would render it unjust to order the enriched party to restore the benefits received, and then you can get damages in lieu of restitution in Article 49. No suggestion that you can assign or novate right to restitution. And in our submission, you can't. It's a remedy, because there must be a liability established in unjust enrichment. It may well have been that there's a liability which Taaleem had to NBC because of the original advance between the intercompany loan. But in order to pass that liability on to Deyaar, you would have had to have been satisfied effectively that there was a separate claim for unjust enrichment against Deyaar. It won't do in our submission simply to say, well, there was an inchoate cause of action available on the 4th of December 2008, which could just be treated as assigned to Deyaar. And I come back really to my primary point, my Lord, which is that if there had been a liability, if Deyaar was to be held liable for the 81 million, one needed to ask more questions and had them answered. And even asking the second question, namely, was there a novation of the Murabbaha agreement, doesn't answer that question either. And again, one can see why now, with the benefit of hindsight, it was in the interests of Taaleem not to raise these sorts of issues, because once one raises them, it becomes very difficult to see how one squeezes everything into a contract made on the 4th of December 2008. No doubt it was very beguiling to ask that simple question, but in my submission it didn't address, simply answering that question didn't address some key features of the case. Now, one way for your Lordship to deal with it at this hearing is to simply to say, well, there was no liability established at trial in relation to the 81 million, and no liability directly said Deyaar, so that claim falls away. I suspect my learned friends would want to argue differently. But the reason I took you to the pleadings is that there is no clear plea of a contract or acceptance of a contract between NBC and Taaleem, far less any terms. So you've seen the sort of interest that is being claimed under that agreement, and one asks oneself, well, where do those terms come from? Where is the liability to pay this profit and this interest on this 81 million? Where does that come from? And then one comes back to, my Lord, the question of interest. I mean, the amount of interest being claimed by NBC is colossal. It's claiming interest at 5.5% plus 2% on top, plus 3% on top of all that, since the 14th of February. Now, if one looks at the actual, I mean, in effect, adds 50% to the value of its claim. I'll show you the figures in a moment or two. But if one goes, if I could just ask you to go back to C362, so bundle 2, which is the Murabbaha agreement itself.
Yeah.
One goes to clause 4.1 again. The buyer shall pay the sale price in accordance with Annexure 2 on the due dates. Well, no due dates were ever established. We've seen no schedule was ever agreed. We've seen that Mr. Subi, it was an oversight, there was never a payment schedule agreed. But even assuming one can imply some terms into clause 4.1 as to the dates of payment within a reasonable time or whatever, well, then has clause 4.2. In addition to the buyer's liability under clause 4.1, the buyer shall also be liable to compensate the seller for the actual loss caused to the seller due to the buyer's failure to pay in accordance with clause 3.2. Unless otherwise determined by the competent court or arbitration, or as reasonably determined by the seller, parties agree that the amount of the late payment charges shall be 2% of the total amount payable by the buyer hereafter, not being paid on the due date. So that is 2% of the total principal. It's not 2% a month or 2% a year, or it's 2% of the total, and that's the figure given in the pleading that Taaleem pleaded. There hasn't been a determination by a competent court or arbitration. It may be suggested that you have determined this issue, but in my submission you haven't. And the seller hasn't determined that it should be more. And if it does now seek to determine that it should be more than 2% of the total, the question of Sharia principles comes up. And if one goes over the page, my Lord, clause 13, this agreement is governed by the laws of Dubai to the extent that these laws are not inconsistent with the principles of Sharia as set out in the Sharia standards published by the Accounting and Auditing Organisation of Islamic Financial Institutions. and as Islamic Fiqh Academy of Organisation of Islamic Conference, in which case the principles of Sharia will prevail. And it's clear that 4.2 reflects those principles. One gets that, my lord, from in the same bundle if one goes forward to tab D. And you have the principles themselves start on page D473, page 802.
Sorry, page 802.
802, my lord. 802.
Yeah.
These are the actual standards.
802 is a blank page.
Sorry, 801, my lord, it must be. I beg your pardon. They start on page 803.
Okay.
First one I'm going to take you to is 805.
Yeah.
Scope of the standard. This standard is applicable to the murabaha, to the purchase order or transaction in its various stages. The issues relating to guarantees before concluding the murabaha deal, such as promise, and issues relating to guarantees for the recovery of the debt created by the murabaha transaction. And then one finds a definition of the kind of murabaha agreement that we're talking about on page 826. So murabaha to the purchase order, the type of transaction which involves the customer's promise to purchase the item from the institution, is called murabaha to the purchase order, as this is distinguished from the normal type of murabaha which does not involve such a promise by the customer. Murabaha to the purchase order is the sale of an item by the institution to a customer for a pre-agreed selling price which includes a pre-agreed profit markup over its cost price, this having been specified in the customer's promise to purchase. Normally, a murabaha to the purchase order of a transaction involves the institution granting the customer a murabaha credit facility. Typically, murabaha to the purchase order of a transaction typically involves deferred payment terms, but such deferred payment is not one of the essential conditions in such a transaction. So that's the kind of agreement we're dealing with. And if one then goes back to page 813, section 5. It is permissible for the institution to stipulate to the customer that instalments may become due before their originally agreed due dates in case of the customer's refusal to perform or delay without any good reason. This may take place in one of the following ways. And then over the page, in 5.6 and 5.8, page 814, it is permissible that the contract of murabaha consist of an undertaking from the customer to pay an amount of money or a percentage of the debt to be donated to charitable causes in the event of a delay on his part in paying instalments on their due date. Sharia Supervisory Board of the institution must have full knowledge that any such amount is indeed spent on charitable causes and not for the benefit of the institution itself. And then 5.8, where there is a default in payment by the customer with regard to instalments of the selling price that are due, the amount due is just the amount of the unpaid selling price. It is not permissible for the institution to impose any additional payment on the customer for the institution's benefit. This provision is, however, subject to item 5.6. So that's the donation to charitable causes provision. And that is what the murabaha agreement reflects. So if one could put away for the moment the Sharia standards, my lord, and perhaps go back to bundle 2.
Oh, we're in it, yeah.
Oh, sorry, go back to the murabaha agreement, which is on the first page.
Yeah.
What one has on first page is a profit. So one has an actual price, the 135,331,061.50. You have the profit, that was paid by Taaleem, and then one has clauses 4.1 and 4.2, and the liability under 4.2 is 2% of the total amount payable by the buyer hereunder not being paid on the due date. So assuming in NBC's favour that all the payments have fallen due, or that terms can be applied that all the payments have now fallen due, the total liability is 2% of the total amount payable by the buyer hereunder. And that is the figure that you've seen in the Taaleem's plea, $2,709,000. So that would mean that the liability, which was assigned or transferred, if indeed it was, to Deyaar, is about 137 million, of which it has paid 50 million. One then looks at the figures that have been claimed against us in these proceedings. Put away bundle 2 and get back to bundle 4. Perhaps best to do it by reference to the order that my learned friend Mr. Kennel is seeking, which we'll find looked at immediately this morning. Starts on page 328.
Yeah.
And one goes to paragraph 3 of the order.
Yeah.
You'll see that what is being claimed from us is 244,315,163. So in subpara A, it's 216 million. So that includes the 81 million.
The 216 million is made, you say, made up of what?
It's the original.
Do you understand it?
The original advance under the Marabaha agreement,
Which was
135 million.
135.
Plus the profit on the Marabaha agreement. I don't think we've been given credit for the profit there paid by Taaleem.
That's profit, which you say is what is that, 1 point.
Which is 1.5 million, give or take.
Yeah.
We've been given credit for 42 million rather than a full 50 million. And the reason, as I understand it, that we've only been given credit for 42.7 million rather than the full 50 million is because NBC has effectively treated part of the 50 million as interest.
Where are you, in a sense, deriving this analysis from?
I think if one goes to page, if one goes back to their pleadings,
Their feelings, I think.
A1 for page 69.
You may be right, but I'm not sure.
If one go, I'm just dealing with the very first figures first, my lord. What the 216,529,699 is the total of all payments made by NBC. One sees that from the table at the top of page 70.
I do apologise, I'm simply not seeing it. The top of page what?
The table at the top of page A1 470.
Oh, yeah, there are 150, 49, okay. The top of page
70, my lord.
70, right.
So that's that's where I get it.
So
That's the first figure.
and that's
Total of all payments made by NBC.
yeah.
And that you can see that my reason for saying it doesn't include, or doesn't give us credit for the Maraba agreement profit is because that is deducted in this table, but isn't in the table in the plenary, but is not deducted in the table in the order.
Anyway, the total payment is 216 million. Yeah.
You can see that we, Deyaar, paid 50 million on the 9th of April 2009. That's in the table.
Yeah.
But in the order, we've only been given credit for 42,763,351 pounds 60, and that's because part of that 50 million has been treated as an interest payment. And I think I get that, but fortunately I've not made a note precisely where I get that from, but I think it's from my learned friend's opening submissions. But if you give me a moment, my lord, I'll just confirm that.
Well, I don't want to waste time. Is that what that is correct? Is it, Mr. Thomas?
Well, yes.
Yeah, right. So
42 million.
42 million
Payment of principal.
50 less
An interest payment.
an interest payment, not a late payment fee, but an interest payment. And it's very close to the late payment fee, isn't it?
Oh, it may be late payment fee, 7 million actually. It is. Maybe it is.
Well, as I understand it, the 7 million something just relates to Murabaha profits. So NBC has taken the payment of 50 million and treated that as the repayment of 42 point something towards principal and 7 point something towards Murabaha profits.
Towards Maraba profit. That's another variation on the theme. I'm sorry, I'm completely lost. It's probably my fault.
Well,
There are figures for late payment, there are figures for Maraba profit, and there are figures for the total paid or advanced by NBC, and of course there's a figure for repayment of any advances or claims advanced by NBC. I'm simply not understanding at the moment.
if one goes back to the order, my lord,
Yeah, I got it.
we've got outstanding total Murabaha profit, so that's to date of judgment, 50,992,699.
So it can't be Maraba profit. Well, I assume it isn't because it...
That's what it says, my lord.
Sorry, what I meant was that the 7 million can't be part of the Maraba profit because it's separated, accounted for in this order.
Well, that's.
Yeah.
Well, I'm not understanding it
Well,
either.
so I apologise, my lord. We may be at cross purposes. Which said, when I'm referring to 42 million something being allocated towards the repayment, towards repayment of principal, we're talking there about the 50 million paid in April 2009. 42 million something is allocated towards principal.
I understand that so far, yeah.
And at that time, the remaining 7 million is towards outstanding Murabaha profits at that time, April 2009.
Okay.
Then,
So the outstanding Murabaha profit of 50 million is as from
must be from the 10th of May. Is that right?
10th of May, what, 2010? No, that can't be right because the figure on page 70 is 19 million on the 25th of May 2010. Well,
If one goes over to 331, you can see the way the profit is calculated.
no, thank you.
Annex B. should have taken this. It's my fault. I had forgotten this set out here. So you've got the original profit on the 216 million, which is at 5.5% per day until the 12th of April 2009. So that's £7,186,264.75.
Now, the 5.5% rate is derived from, you don't know.
I've got no idea.
That's the Murabaha agreement rates.
Ah, well then I've missed that in the agreement. We'll have to see that.
There is no.
Anyway, it's alleged to be the profit rate under the Murabaha agreement.
Well, I'm going to get back to that in a minute because that's helpful.
I don't know. Well, I mean, the only percentage figure I saw in the agreement was 2%.
Exactly.
Would go to charity.
And so I do challenge that, my lord.
Hmm?
And then there is 5.5% per day, effectively, from the 12th of April 2009 to the 19th of February.
Because by now the figure has been decreased by the allocation of 42 million. Is that the point?
That's right, my lord.
Yes. Because the 50 million is paid on the 12th of April.
Yes, my lord.
2009. Okay. I understand that. So again, right, and then we've got the late payment charges, which is the 2% under the Murabaha agreement.
And the net effect of that is it's 2% per day.
Yes, not 2% on the global figure.
It's 2% per day.
Per day.
And you'll notice, my lord, it's been claimed from the 31st of August 2008 onwards. So what we're being treated, we were as if we were liable to repay everything on day one, and we've got to pay an additional 2%. And of course, it wasn't actually signed, remember, my lord, until the 21st of October 2009. So we're being treated, in effect, what is being asked for is an interest rate of 7.5%. And you, my lord, have seen the terms of the agreement, which provide for a total late payment charge of 2% on the principal full stop.
For charitable purposes.
For charitable purposes. And this claim...
Okay, well, I understand how you understand it. I follow that. Well, I'm a little bit dawning on me.
And you can see the total figures that we're talking about, Lord, which is...
And that's paragraph 3. The
70 million in total. In interest.
Yes, I understand.
And again, when it comes back to this point, which is that the finding that the court has made is that there was a transfer of the interest on the 4th of December 2008. And one asks oneself, well, even if one is prepared to extend that to the Murabaha agreement, contrary to my primary submission, how or where does this obligation come from to pay these rates, and how can it be consistent with the terms of the Murabaha agreement itself?
Well, I understand your submission, thank you. Yes.
My lord, it may be, I hesitate to interrupt, but it may be helpful for me just to clarify that that the 5% as against Deyaar comes from a document, from Deyaar's own document. We can go to, I apologise for interrupting, but bundle 3, probably volume 2, and it's page 5970.
So I couldn't hear
5970. My lord, you'll see this is...
Sorry, I haven't got that yet, sorry. I've got it now, yeah.
You'll see here, this is an email from Deyaar, Krishnamurthy, Finance, to Mohammed Kasim Al-Ali, that's NBC's CEO. you'll see he says, Mr. Cassim, please find attached here with the details and the profits accruals on the Mirabah financing by NBC.
So just remind me, Mr. Mohammed Cassim is...
He's NBC's CEO.
Yeah.
He gave evidence before your lordship. Krishnamurthy is Deyaar Finance, who of course did not give evidence. And Krishnamurthy says, Dear Mr. Cassim, please find attached here with the details and the profits accruals on the Mirabah financing by NBC. My copy of the document has a hole for the first word. I suspect it says we confirm these amounts to be correct, and we will be signing the Mirabah agreements. I think that's once they're done. Should, in the event the transaction is reversed, we reserve the right to claim back the amount paid. If we go over the page, we get the calculations there.
Well,
well, I understand that the following page, page 597, might not be in the bundles.
I don't have it.
Likewise.
So we see there, my lord, we have we're on page 5971, and so you can see that we have three tables. Now, the first of those tables has three payments. This is in the amount column, which total 135. Those are the three initial instalments paid by NBC on behalf of for Taaleem under the tripartite agreement, and they come to 135 million. And we see there's the calculation of the Mirabah profit there at the rate of 5.5%, and the Mirabah profit up until the 31st of August 2008 on that 135 million is 1.492 million. Now that's the profit figure in the Mirabah agreement, and so you can see where that 5.5% figure comes from, and that 1.49.
Well, sorry, can you just show me it? At the moment, I'm not quite sure what I am looking at in the Mirabah agreement in relation to 5.5%.
Well, my lord, the figure at the bottom of that first table, the figure in the bottom, not the bottom right box, the one above that, it says total 1.492.
Yes.
698.62. That's the profit figure stated in the Mirabah agreement between NBC and Taaleem.
Oh, I see. I'm so sorry. I misunderstood what you were saying. That is the profit figure. Yes.
In the Mirabah agreement. Yes.
I'm sorry.
And so you can see.
So it's got nothing to do with 5.5%. Just
yes,
the figure.
Well, yes, my lord. It's got everything to do with 5.5% because we can see in this table that that's how it's been calculated.
Okay.
And we can check, but I think there are likely to be similar documents or a similar table from 2008, which
okay, I'm beginning to understand the point now.
Your Lordship will see. So we see there that profit figure of 1.492 million is calculated on the basis of 5.5%.
So, I mean, the simple point is that you are saying that implicit in the 1.492 profit figure is an interest rate of 5.5% per day.
Yes, not per day. That would be.
And therefore, if one is looking at profit, slightly strange use of the word, but profit in the period after July 2008, one would calculate it on the same rate.
Yes, my lord, and so if we move on to the second table there, we see that this runs from the 1st of September 2008. And of course, the 31st of August was the cut-off date because that's when Taaleem wants to have sold the interest by then and wants there to be a new buyer. And so we then get the second period, which runs from the 1st of September 2008.
Right.
And so we have that initial amount of 136, which is the 135 plus the profit. My lord, I just want to check it is helpful for me to deal with this at this stage.
Yeah, thank you for drawing my attention to this.
But I'm happy to let my learned friends continue. I think that's interesting.
Well, my lord, can we just...
Can I just understand the 81 million which comes in both box 1 and box 2 is the same figure, correct?
No. The payment in the top box
is the first instalment.
Exactly. That's the third instalment of 80.
The third instalment,
which
and then the next one is the fourth.
Exactly. The one with the date 11th of September 2008.
The fourth instalment. Okay. No, I understand. Thank you. Sorry for this. Yeah.
My lord, this simple point I'd make in answer to the point that's being made is that if one goes back to page 5970, so
Back to
5970, the email itself that we're looking at.
Yeah.
Please find attached here with details and profits accruals on Murabaha financing guidance. We convene these amounts to be correct, and we will be signing the Murabaha agreements. And I can't read because of the whole punch.
Once they're done.
Once they are done. So box 1 does relate to the first Murabaha agreement, the one that we've been looking at.
Yes.
But boxes 2 and 3 relate to agreements that were never signed by Deyaar. And this comes back to my point really in relation to the 81 million, which is it was always contemplated that the way, in fact, that Deyaar would assume the liability to NBC was by signing a series of 3 new Murabaha agreements. They may even, I think, have been included with this email or one. Very close to. But those agreements were never executed. And to say now that as a consequence of the finding that your Lordship has made, and one can see that clearly from the statement there, and we can, if you like, my Lord, find the drafts that he is referring to, because they are in circulation. But to spell out of your Lordship's finding that because there was a contract on the 4th of December, we assume these liabilities, my Lord, is going too far. There was if your Lordship is satisfied that we did assume liability under the Murabaha agreement, it was to pay the first profit, the liability which in fact Taaleem had already discharged, and it was just simply to pay the late payment charges of 2%. The Lordship has not decided cannot have decided in our submission, my Lord, that we assumed any further obligation. And one does look at the date on this document, the 4th of June 2009. And again, I come back to the same point, but simply by asking your Lordship to decide agreement or not on the 4th of December 2009, it left a whole series of issues outstanding. The terms of the Murabaha agreement on the dated the 6th of July 2008, executed on the 21st of October, are in our submission clear. And we also do rely, my Lord, on...
Sorry, let me just understand your submission then. If and to the extent there was an allocation of responsibility under the agreement reached to transfer the property to Deyaar and assume for that purpose accompanied by a transfer of responsibility under the Murabaha agreement, the limit of Deyaar's exposure was any outstanding principal as at that date, together with responsibility for late payment charges of 2%,
Yes.
and no more.
Yes. I mean, those were the only outstanding obligations in existence between Taaleem and Deyaar.
And it would, you couldn't add on any further charge in respect of late payment by way of an interest claim.
No one couldn't, because the terms are clear.
Yeah.
And this gives rise to the question of the Sharia principles and the extent to which they are incorporated into the contract, because that kind of interest would have been prohibited by the Sharia principles. One can make a late payment charge. One goes back to bundle 2. Tab D.
I'm so sorry, where are you?
Bundle 2, my lord. Tab D.
Yeah.
And if one goes to page,
Well, you're back on 5.8, right?
no, it's 4.8, below on page 8112.
There we go.
So you can have late payment charges, as we've seen, limited, and then 4.6. It is an obligation of both the price of the item and the institution's profit on the murabaha should the purchase order or transaction be fixed and known to both parties on the signature contract of sale. It's not permitted under any circumstances to subject the determination of the price or the profit to unknown variations or variations that are determinable in the future, such as by concluding the sale making the profit dependent on the rate of LIBOR that will prevail in the future. No objection to referring to any other known indicators during the promise stages or comfort indicators to determine the rate of profit, provided that the determination of the institution's profit at the time of concluding murabaha to the purchase order is based on a certain percentage of the cost and is not tied up with LIBOR or a time factor. Institution's profit markup in murabaha to the purchase order must be known. The mere mention of the total selling price is not sufficient. Permissible profit be determined based on a lump sum amount or a certain percentage of the cost price only, or of the cost price plus the expenses. This determination is completed by the agreement of mutual consent of the two parties.
Thank you. Ignacio. Turn the air conditioning down. Yes.
This is one of the principal reasons, my lord, why we wish to be able to raise the question of, or to argue the question of Sharia law, and the reliance on these principles. Because my learned friends take the
Well, I don't know to what extent that's controversial. I mean, certainly there was a disclaimer of any significance of Sharia law in relation to the issues of liability. I don't think the question of its significance in relation to issues of quantum was ever raised. If we can grapple with this point now, let us grapple with it. I'm saying let's not go off another day.
Well,
Or you're contemplating going off for another day.
well, I'm really in your lordship's hands, but it depends to some
Well, we're
extent.
spending enough money on this case as it is. Right. Government knows what the costs are. Anyway, your point is that it's manifest that, I'm not saying you're right, but I'm just saying you say it's manifest that a Sharia law is applicable to the quantum of the claim, because there is a limit to entitlement to charge for late payment, and indeed a restriction on the recipient of any payment in respect of late payment.
Yes.
And that the effect of that would be to
limit our liability.
limit your liability in respect of
payment
or something like, I can't see, it's
Well, I can give you the figure, my lord. It's
146, is it?
well, if one goes back to the sale agreement of tab 1, the first page of tab bundle 2, that on tab C,